on the record. The time now is 51 minutes past 1 o'clock. It's 51 minutes past 1. And the date is Thursday, February 18 of the year Lord 2020. This court is now open and on session under Title 28, Section 636, Golf, Subchapter 636, U.S. Code Section 636, Subchapter Golf, Martial Law under Rule 203, Jurisdiction over the offense. This is a court of jurisdictional powers and temporary assignments. The case number was read. It's going to be read again so that we know exactly where we are. Case number Delta dash 1314 dash Charlie Victor dash 2019 dash 01401. In video number 5, we were doing a cross-examination for the Honorable Jesús-Arriaga Ponce. It was conducting a cross-examination. I will continue in the cross-examination now of criminal attorney at law and judge. The attorney at law is uncertain what name she is using because we have forensic evidence that she's got 5 names. 5 names, perhaps 6. I want to bring it to the screen. The information is here. This is forensic evidence that you are in violation of 6 CFR 37.3. You're not using your real name. You cannot proceed. I mean, if you didn't know that, you're at a loss. You're a total moron. You have no authority, you have no license, no agency, you have no standing. And one, Cindy M. Mercer, the same. You've been disbarred as of August 30th of 2020. For all of you trespassers listed, correspondents, rapist listed on attachment 1 of each case, this is forensic evidence, and to the attention of the Honorable Esquire John G. Roberts, Juliet, Oscar, Hotel, November, Golf, capital, letter, capital Romeo, Oscar, Bravo, Echo, Romeo, lowercase, Tango, Sierra. You will agree, correct? That in all legal process, the legal name shall be used. And there is no exceptions. It's federal. It's Code of Federal Rules. 6 CFR 37.3. We are now on page number 4 of the perjury submitted by none other than the criminal listed on this document. We can see clearly that this is forensic evidence that one Elizabeth V. Freudenstein is not using the real name, and therefore this document is worthless. So as worthless as her performance. It's the performance of the criminal trespasser. In video 5, we were looking at the fact. She's bringing a fact. Lawyers cannot bring any facts. And this is something that she is, one Elizabeth B. Friedenstein is brought to the record. And now, Elizabeth B. Friedenstein, you are charged with violation of Title 15, Section 1692E, bringing false and misleading information or representations into the record. And you wrote, district courts are attached for unknown reasons. Page 28 of the criminal complaint has a heading that alleges that additional judges in the 13th Judicial District Court are trespassers. In means no. In means no. So it's not clear what you're trying to bring across here. Trespassers, wrongdoers, rapists, and correspondents. The irrelevant, scandalous, and nonsensical documents go on for a total of 68 pages. Final answer. For the Honorable J. Jesús-Arriaga Ponce has 45 perjuries, and this is willful perjury because you knew or you should have known. You went to school, didn't you? You advertised as an attorney at law, maritime law, and Martindale's. You can go and look at the website, look for this criminal, Elizabeth V. Friedenstein, and it states in there that you are an attorney at law who specializes in maritime law. Where is your contract? You don't have any contract in maritime law. You should have a contract, and it's all about the transparency of the contract. In the September 1st hearing, the contract was to be furnished within 3 days. And as of today's date, which is Thursday, February 18, not on the record. Not on the record. So now you're in violation. If you were asked for that contract, presentment is under UCC 3501. So you have failed to present a contract. You failed miserably. You don't have a contract. How can one Cindy M. Mercer proceed to practice contract law without a contract? The contract makes the law. If there is no contract, there is no law. If there is no law, there is no jurisdiction. And if there is no jurisdiction, then you don't have a case. And you are asked, compelled by Squire Roberts Jr. to cease and desist, to stop. So 45 perjuries and one more violation to Title 15, Section 1692E, which carries penalty of $2.5 million in lawful money, which is $25 million. And then you're going to jail for another 30 years. Okay? Perhaps Squire Roberts and the Supreme Court for the United States, and perhaps Chief Justice Johnson, in the United States District Court, in the corporate United States District Court for the corporate district of New Mexico, cannot say any different. Or else he will come down to Guantanamo with you. You're going to be in Guantanamo for the rest of your life for terrorism, domestic terrorism. Willful acts of terrorism are punishable. And it is forensic evidence here on the record in this trial by record. As the record shows, page 4, defendant's arguments are based on the universally rejected. Final answer? In one of our prior videos, in the case that ends on 392, it is a state. It is in the record. The UCC connection. We play a video for the record that states that the sovereignty rests with the people. The Supreme Court for the United States, we're going to need this book in a little bit. The Supreme Court for the United States clearly says that the sovereignty rests with the people. But first, we're going to continue the challenge of this bogus garbage submitted, these false claims in violation of Title 15, Section 1692E, brought in by criminal. Whatever the five names, whichever of these five names is your name, you are a criminal. Defendants' arguments are based on the universally rejected. UN means no. IBE is no, is contract, so no contract. Un means no. A vowel and two consonants followed by two consonants means no contract. Can you challenge? Absolutely not. As we say at the beginning of video 5, this document here is bogus. Is written in a bastardized language, in violation of the language requirements for this Superior Court of Record. Now, you're familiar with violation of Title 18, Section 1001. It is unlawful to bastardize the language. And you have sovereign citizens. Final answer, there is no such thing. And please refer to the video. Refer to the video. Can you challenge the Supreme Court of Justice, the Supreme Court for the United States? Can you challenge the corporate United States District Court for the corporate district of New Mexico? Okay. What is defendants? DEF? DE means no. FEN? END is no contract. And ANT is no contract. And ants are ants. No contract, ants. Now, arguments. Your final answer, is this an argument? This is standing decision by the Supreme Court for the United States. So you are telling Squire Roberts Jr. that these are arguments? Well, this document is now forensic evidence of your wrongdoing, of your trespassing, of your false and misleading representations in violation of Title 15, Section 1692E, echo, lowercase. Sovereign citizens move. It's either you're a citizen or you're a sovereign. You cannot be both. Can you be a master slave? It's either you're a master or a slave. In video 5, we say that the people own the government. Can you go against that? Final answer? I'll write you up another perjury, 46. Because it's not. And you have furnished this as perpetual information, perpetual representation in violation of Title 15, Section 1692, echo, lowercase. 46 perjuries. Sovereign citizens movement. Okay. In item 3 of page 4, the Second Circuit Court of Appeals has noted. Final answer. Where where in the record you furnish that note. And if the Second Circuit Court of Appeals has no, and all means no, and what is TED? Has noted that. And then you write over here, whatever this little t means, this lowercase t in brackets cannot even be considered. What is that? No additional information and description or information to specify what this little letter stands for. And then again, the sovereign citizens. There is no sovereign citizens. 47. You are an idiot. And all attorneys at law are idiots. You cannot go against this. Can you challenge? Sovereign citizens are a loosely affiliated group who believe. Do you want to call the people a loosely affiliated group? The people wrote the Constitution. Go look at the preamble in one of our videos that we posted here. That's why we put it in there. Go and find it in there in the entire Constitution. Where does it say that the people are sovereign citizens and they are a loosely affiliated group? Perjury number 48. The people are sovereign. They are not a loosely affiliated group, and they don't believe that the state is considered them as citizens. And if there is a misunderstanding, for the Honorable J. Jesús-Arriaga Ponce and for the Honorable Adelina Arriaga Pedrosa clearly state they are one of the people. Who believe that the state and federal governments lack constitutional legitimacy. Well, they lack constitutional legitimacy over the people. Constitutional legitimacy. And therefore have no authority to regulate their behavior. So what you're saying now is that the code regulates people? Final answer? The Universal Code, the Uniform Commercial Code does not. and let me repeat it, does not regulate people. Another perjury. 49. Number 49. Perjury number 49 at $15,000 each, and you have 15 years going to prison for each of this. You're not getting out. Plus you got 30, 60, 90, and we are only on page 4. We still have 2 pages and have no authority to regulate their behavior. Now, you write a code over here. Perhaps you didn't read in the criminal complaint that UCC 1-109, 1-109 is private property, and that 103.6 reads clearly that the code cannot be read to preclude a common law action. Another perjury. Perjury number 50. And the fact that you're writing code and that the rights are reserved under UCC 1-103.6, you're at a big disadvantage. You're showing you don't know what you're doing. You're negligence. Number 4, courts have noted that one of the identified features of the sovereign citizen, final answer, courts have noted. Where's the note? You don't bring it here. You're supposed to bring law. You're not supposed to bring a comment. Now, courts have noted. Where? Where exactly? Show me the law. Courts have noted that one of the identifying features of the sovereign citizens and the related redemptionist movement is an emphasis on the capitalization of names. Absolutely. Are you a coroner? Only the coroner can identify, can write names on capital letters. Are you a coroner? No, you're not. If you say yes, you're lying. And if you wrote this name with capital letters, that's infringing on the real name by making a false advertisement of a corporate name. Where's the bylaws? Capitalization of names. Now, perhaps you didn't read the cv-201901401. cv-201901401 is the one with life. Perhaps is noted, as the record show, that for the Honorable Jesús-Arriaga Pedrosa is appointed personal representative and executrix for the all capital name. Can you go against that? No, she is protected under the Uniform Commercial Code 3-402. And we went over that on the video, on the part 5. This is part 6. This is going to be part 6. And this is not a movement. This is the people who wrote the Constitution. Additional punctuation added to names and added unsuitable titles. Final answer, unsuitable title. If the people's sovereign, and it is a standing decision by the Supreme Court for the United States, you are daring to say that unsuitable titles to names. Unsuitable titles on what respect? The punctuation is there because it makes the name a fact. Can you bring a fact? No, you can't. Lawyers cannot bring facts. And you're bringing a fact. And the punctuation is there for a reason. Punctuation added to names. So now you agree that they are names, correct? Another perjury, 51. And then you write code over here on violation of the Uniform Commercial Code 1-103.6. What is defendants? And again, defendants. Defendants, def, and ants. Another perjury. Violation of title, violation of the Uniform Commercial Code 1-103.6. Another perjury, perjury number 52. And perhaps Squire Roberts cannot say different. Can you? Squire Roberts? Can you say different? The answer is no. Because if you say different, you go into Guantanamo for the rest of your life. Findings have repeatedly signed documents with variations of honorable. Honorable. Now you question the honorability of the king by saying there is not. There is a variation. It's not a variation. Variation is the people's sovereign. That's a variation. You're lying. Going down. Perjury number 53. I wouldn't want to be in your shoes. And believe me, when they find out that you're a lawyer over there in Guantanamo, I don't think you have a chance. And for the Honorable J. Jesús-Arriaga is placing a restriction order on this video for Justice or Squire Roberts to enforce. Protection order, you cannot get any near. Now you are forcing or forging the name of a federal judge, J, period, column. You're missing a column. J-E-S-U-S, Juliet, Echo, Sierra, Uniform, Sierra, hyphen, Alpha, capital letter Alpha, Romeo, Romeo, India, Alpha, lowercase, Golf, Alpha, column, Alpha, Bravo, Oscar, November, Charlie, Echo, lowercase, and is missing the period. And the Honorable column, Adelina, hyphen, Arriaga, column, Pedrosa. Forensic evidence of forgery or using a trademark of a federal judge to bring false and misleading informations in violation, false and misleading representations in violation of Title 15, Section 1692E. They're not honorable. Final answer? Now, you know, this one here is going to cost you another 30 years because it's violation of Title 15, Section 1692E. I got another one here. $2.5 million, $25 million on real money and lawful money, and another 30 years. You got 30, 60, 120. Just on those 4 violations, you got 120 years. You're not getting out of Guantanamo. Defendants appear. Defendants appear. Defendants appear. Okay. You are listing on number 5, item 5, page 4, the def and ants. Def and to end ants appear. Where do they appear? Def and ants appear. Appear. Final answer? There is no defendants, perjury number 54. To have a superstition about zip codes. Final answer. Final answer. Superstition. What is the word superstition about zip codes? For the Honorable J. Jesús-Arriaga once and for the Honorable Adelina Arriaga Pedrosa does not live under any zip code. They travel the world on aid of the sick and wounded of the world's military. Where is the address? Where is the legal address? Do you have a legal address? For the Honorable J. Jesús-Arriaga once and for the Honorable Adelina Arriaga Pedrosa, they don't have an address. And if you state they do, well, perjury number 55. You don't have a legal address. Zip codes, as well as evidenced by lack of reduction of the zip code. Lack of reduction. How can you claim that you live under a zip code if you don't? Lack of reduction. Well, you know, right there, that very minute, you should have seen, well, these people are not living under any code, and therefore they are not subject to any law of the United States. Those who invoke a zip code are invoking federal jurisdiction. You're a total loss. So now another violation of Title 15, Section 1692E, another 30 years. So we have a total here of 30, 60, and 60, 120. You got 150 years just on this. So far. Pleadings. Zip code and defendants. Pleadings. Pleadings. Animals plea. A goat plea. Bleh. Oink, oink. Es a plea. For the Honorable J. Jesús-Arriaga once is one of the people. People speak. Final answer, defendant's plea. 56. People do not plea. Animals plea. And this goes for you, Judge John R. Chavez. When you come over saying, what's your name? And what's your plea? How do you plea? It is on the record. Animals plea. People speak. You're dealing with one of the people. You shall know right there to run away, deceased, dismiss. No. Now is willful tort of malpractice, and your insurance cannot argue any different. This is consistent with the sovereign citizen ideology. Oh, sovereign citizen, final answer? Another perjury, 57. Chisholm versus Georgia. The sovereignty rests on the people. And again, another 30 years for bringing false and misleading information in violation of Title 18, Section 1692E. You have 180 years on that. Plus, you know, the last time we checked here are 40 perjuries are 15 years each. On 10 is 150. 20 is 300. So you got 600 years. Which teaches the individuals might be deprived of their rights if they accept mail with the zip code. Absolutely right. Absolutely right. And you have a code here, right? Francis X. Sullivan, comma, the usurping octopus of judicial authority. That's right. Silent jurisdiction. The jurisdiction was questioned. Your authority was questioned. You don't have enough that satisfies the Article 6 of the Constitution. You are in violation of 1 Stat 23, page 1, section 1, or section 1 of page 1, whatever you want to look at it. Go look at it. It's 1 Stat 23, section 1, page 1. Also in violation, one Cindy M. Mercer and one Elizabeth B. Feinstein, and all the attorneys and all the lawyers on all these 5 cases are in violation of the same Title 4, Section 101. And it was, they all were given the opportunity to bring that, the documentation in the United States in the corporate United States District Court for the corporate district of New Mexico. It's on the record. Squire Roberts Jr. Cannot tell any difference. He cannot come over and bail you out, say that you are right, because he is right and you are wrong. But if he wants to bail one Cindy M. Mercer and one Elizabeth B. Lawton, then all 3 of you are going to Guantanamo for a term for the rest of your natural life. And then another code over here. Cities, Sovereign Cities Movement 1999. This is rejected. No code, no statute under common law. Final answer. You're in violation of UCC 1-103.6. You're reading code to preclude a common law action. A violation of UCC Uniform Commercial Code 1-103.6. Can you tell me different? Show me the law. 6. Defendants inclusion. 6. Defendants. Again, defendants. We continue with the nonsense. With the nonsensical. Deaf means the hearing impaired. And is the end of something. And ants is ants. Little ants. And then inclusion, INC stands for corporation. SION means it's an illusion. And ION is no contract. Defendant's inclusion of the phrase UCC 1-308, 103.6, and 09. Man, you're going to suffer on this one here. UCC 1-308, 103.6, and then you write 09. Did the Honorable claim any UCC 09? Bogus. It's on this document. Does this look like a 09 or is a 109? It's a 109, right? 1, 2, 3. 3 more perjuries. 57, 58, 59, 60. Inclusion of the phrase UCC 1-308, 103.6, and 09. You're lying. Perjury. And the nonsensical continues in your document. And remember, you are in violation of the bond requirements of the Superior Court of Record. That's $2.5 million. You have no performance bond. You cannot perform. You owe this court, the Superior Court of Record, for the Honorable J. Jesús-Arriaga, is $100 million. And your insurance cannot say different, because your insurance will go down as well. Your insurance is, if your insurance wants to challenge, they can challenge. But you know, in fact, we are taking the time to go to the library of the Supreme Court have a copy, have it certified, and we're going to bring it on the record on the following video. And this is to target you on that one. Sorry. You are sorry. You don't know. The signature blocks is also an indicator that the subscribers to the sovereign citizen movement, the signature blocks is also an indicator. So you're familiar with this. What is the signature blocks? Corporations sign. People have autographs. When is the last time you came over to Jack Nicholson? I say, hey, can you give me your signature? They don't have signatures. Corporations have signatures. People have autographs. Another perjury, 61. Sovereign citizens are known for engaging in paper terrorism. Oh! Final answer? Must be your final answer. You wrote it, correct? You wrote it. It's in the record. On the record. Not in the record. It's on the record. In means no. This is going to cost you big time. Another 30 years. This is bringing false and misleading representations into the record. Sovereign citizens are known for engaging in paper terrorism. Number 7, another perjury, 62. Paper terrorism. This is terrorism. You are a terrorist. You have no license. You have no authority. You are usurping. You are usurping. You are the terrorist. One Cindy M. Mercer, for the record, is a terrorist. One Elizabeth B. Lawton or Elizabeth Fry or Elizabeth, whatever of these names is your name, you are a terrorist. Terrorists have several names, and you are one of them. All of you judges, all of you lawyers are in violation of 6 CFR 37.3. Through frivolous legal filings. Oh, frivolous, final answer is 1-308 frivolous. Is 103.6 frivolous. Is 109 UCC 1-109 frivolous. Final answer, 3 more perjuries. They're not frivolous. Unless you want to call the whole Uniform Commercial Code frivolous, which Esquire Justice is not going to agree. It's not frivolous, is it, Chief Justice? Esquire Roberts, is that frivolous? You agree that it's not frivolous, correct? See? He said no, because if he said yes, he's coming with you to Guantanamo. So not frivolous. To call the Universal Commercial Code frivolous is going to cost you another 30 years, because that's violation of 15, Title 15, Sections 1692, Echo, lowercase. So another 30 years. You had 210 on this one already. 210. 210 years to prison. And recording false liens. False liens? You want to talk about false liens? Where is the master mortgage? And where is the master mortgage form? Did you furnish the master mortgage form? Well, then your lien is frivolous and locks. To be bonded. It's not bonded. You're supposed to, in commercial, you're supposed to bring the remedy. You didn't know that, counsel? You didn't know that, chief lawyer? Cheap lawyer, you didn't know that? You're supposed to bring a bond 3 times the amount, and I believe you're claiming over $90,000. So you're going down for this. You're going down. Now you have to pay 3 times the money. Let the record show that one Lisbeth B. Freisenstein, Lisbeth Lawton, or Lisbeth Fry wrote in this document, in violation of Title 15, Section 1692E, that for the Honorable J. Jesús-Arriaga Avonce and for the Honorable Adelina Arriaga Pedrosa are filing false liens. And then you put this sign over here. What does that mean? And why did you put the entire law? Sovereign citizens will wage that has been termed campaigns on perpetuate terrorism. Sovereign citizens will wage that has been termed campaigns of paper terrorism. Final answer. Perjury number 63. There is no way you can claim on earth or any place that the people are not sovereign and that the people are terrorists on paper. The sovereign citizens theory. Sovereign citizens theory, that's a theory of yours. Because there is no such thing as sovereign citizen. That's a theory that you fabricated in violation of Title 15, Section 1692E. Another 30 years. 240 years in violations of Title 15, Section 1692E. Unrelated paper money and redemptions. Is Federal Reserve note redeemable for gold and silver? Final answer. If you say yes, you're committing perjury. If you say no, in this document, you're committing perjury. Because now you're arguing otherwise. So 2 perjuries, 63, 64, 65. And you're gonna have to stand by because I will have to take this phone call. Sovereign citizens are known for engaging in paper terrorism. That's a perjury. And you gotta watch that video. That's why we put it here. Number 8, sovereign citizens theory. Again, and redemptionist, RE means no. Theories have been rejected in every reported case. To consider them, see Stevenson versus Bank of America. Final answer. This is code. You cannot read code to preclude a common law action, and that's perjury number 66. These filings were based closely on the vapor money and redemption movement theories, which have been roundly rejected by courts across the nation. Which courts exactly? Courts? You don't say who exactly. And then you continue writing code. Well, that's another perjury. Because the courts are not sovereign. Chisholm versus Georgia. The courts and the state is not sovereign. Another perjury. Perjury number 67. And you know this day was coming. And then you write code over here. That's another perjury. Since when the code applied to people? You don't have an answer. If you said yes, you're lying. If you say no, well, then you're right. But you are writing code to preclude a common law action. Another perjury. Perjury number 68. Rejected by across the nation. Where is this nation? Where is this nation? Nation. Nay means no. ION is contract. No contract. Against the no contract, internal quotations and citations submitted. Perjury number 69. And this code is worthless when it comes to common law action, and you know it. You're violating Uniform Commercial Code Section 1-103.6. There you go. That earned you another 15 years. Plaintiffs' claims are promised on the so-called paper money. Well, can you claim that the plaintiff is asking for money? There is no money in the United States since 1933. Everything before 1933 is common law. Everything past 1933 is public policy. And the remedy is 1-308 because the commercial code has to give you a remedy. Whereas you reserve your rights, the code cannot be read under 1-103.6. Final answer? Perjury number 70. 70 times 15. 70 perjuries. Willful. Simple perjury is 5 years in prison, 5,000. Willful, calculated, intentional, 15 years to prison and $15,000. Your insurance is going to kill you. Your insurance will agree. Plaintiff's claims are premised on the so-called paper money theory. Is bogus. Is Federal Reserve note redeemable for gold and silver? Final answer. If you say yes, you're lying. If you say no, you are agreeing to your own lie. Two more perjuries, 71 and 72. 72 perjuries, which has been consistently rejected by federal courts as frivolous. Federal courts, final answer. What federal courts? Federal courts say that that it is frivolous to claim your rights under the UCC 1-308. You're lying. That's another lie. That's another perjury. 71, 72, 73. And then this code here cannot be read. Petitioners' assertions appear to be based, at least in part, on the redemption theory and the related sovereign citizens theory. Okay, final answer. 74 and 75. Related to sovereign citizens theory. It's not a theory. What is a theory? Theo is God. Since when God or your God has to be in between this? In which one of the 5,000 gods? You're lying. Another perjury. 76. 9. The Federal Bureau of Investigations has identified the sovereign citizen movement as a domestic terrorist group. Final answer. Because they have not. Federal Bureau of Investigations has no documentation to claim that the people are terrorists or that reserving your rights under the Universal Commercial Code, UCC, Uniform Commercial Code, Uniform Commercial Code, Uniform Commercial Code 1-308. Final answer? Now you're going to have to bring that document. And you will never... Where is the document? A domestic terrorist group? You're lying. That's perjury number 80. And then domestic. Since when? If you read the zip code, X, 99-98, November Delta is non-domestic. The Honorable, and for the Honorable J. Jesús-Arriaga Abonce, and for the Honorable Adelina Arriaga Pedrosa, never, ever on the record have claimed to be domestic. So if the Federal Bureau of Investigations is talking about a domestic terrorist group, well, the Federal Bureau of Investigations is bringing false and misleading information into the record in violation of Title 15, Section 1592E. You get another 30 years for this one. And now on this side you got 270 years because we're gonna make it happen. And Esquire Roberts is not going to say no, unless he wants to come to Guantanamo with you for life, and with all the trespassers listed, the correspondence, rapists, trespassers, wrongdoers, listed on attachment 1 of each case listed on this criminal complaint. There you go. Take your shot. Squire Roberts, take your screenshot. So we said, and then there's another perjury because 9 is a perjury, and that's 81. 81. Sovereign citizen movement. Again, can you have a slave master? No. You're either a sovereign or a citizen. Do you have any evidence that for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa are citizens or U.S. citizens? You're on the dark. You're lost. If you want to portray the judge, the federal judge, as a citizen of the United States, you are committing perjury. And that's 81, 82, and 83 for the Honorable Queen. Column. Adelina, hyphen, Arriaga, column, Pedrosa, period. Responding to arguments associated with these theories. Arguments, final answer, is an argument to reserve your rights under 1-308 UCC of your UCC. Perjury number 83. Associated with these theories. He said there is no need to refute these arguments. Who said there is no need to refute these arguments? If FBI domestic terrorist, the sovereign citizen movement, December 10, 2014. And where is it? So you're saying that the Federal Bureau of Investigation has declared that there is a movement out there with sovereign citizens? Well, the FBI is committing perjury because there is no such thing. There is a group out there of slave masters. You're at a loss. Go to the citizens versus people. You're lying. With somber reasoning and copious citation of precedent, to do so might suggest that these arguments have some colorable merit. Colorable merit, final answer, colorable law for colorable money is Federal Reserve note, real money. Colorable law for colorable money, and you color people as corporations when you falsely steal their identification to fabricate a bogus legal entity and then file the claim. And we read the inclusio, and that's another perjury for you. Perjury number 84. Defendants shall be barred from proceeding pro se. Oh, you're going to suffer on this one. Under what authority you can be barred, ma'am? Under what authority? Oh, don't let him do that. It has to go through one of our State Bar Association lawyers, esquires, agents for the Crown of England. Do you have evidence? Number one, that for the Honorable Adelina Arriaga Pedrosa engages in interstate commerce or uses the road for profit? You're violating the right of travel, the right to travel. Now, she travels the world in aid of the sick and wounded of the world's military. Can you detain someone from the National Red Cross who is protected by the Geneva 4 Conventions, by the Geneva Conventions 4 of August 1949 and Protocol 1 of June 1977? No. Another perjury, another two perjuries, 85 and 86. I wouldn't want to be you, honestly. Okay, now what PRO means no, SE is to say. So proceeding, PRO, no, ceding. What is ceding means? ING is no contract. Cede, PRO, no cede contract. No say, PRO, PRO means no, cede, cede is a cede, ING is no contract, and PRO is no, and SE is to say. How could anybody proceed without saying anything? Final answer? No? Okay, well, final answer. So this is three more perjuries. 86, 87, 88, 89, 89. Number 10. Courts faced with these arguments have sometimes found it necessary to enter orders prohibiting, PRO means no, the litigants, asserting them from filing pro se, and the 10th Circuit has upheld those orders. That's a lie. Now, this is code, right? Code Cannot be read. You're violating the UCC 1-1.1-103.6. Another 30 years. On this side, you got 300 years. Non-presidential. Final answer. Can you proceed on the common law or no? You say no. Final answer. Perjury number 90. 11. Courts have also found it proper. PRO means no. PER means no. No. Personal. No personal. Perjury number 91. To enter Rule 11 sanctions. Rule 11 is for lawyers. Is Rule 11 applied to people? Final answer? It doesn't apply to people. You can go and look for it. If you bring me the fact, which you can't, that Rule 11 is for people, number one, people shouldn't have to be in your supermarket court because right off the fact, you are in violation of the corporate law for applying it to humans, and that's human trafficking. So I'm hereby charging for the Honorable J. Jesús-Arriaga and for the Honorable Adelina Arriaga Pedrosa are charging one, Lisbeth B. Feinstein, Lisbeth B. Lowton, Lisbeth Lowton, or Lisbeth Fried with perjury and bringing false and misleading information in violation of Title 15, Section 1692E. So another 30 years over here. So that's 330 years. And, well, judge, have you ever sanctioned people under Rule 11? You have to sanction this lawyer because obviously she's bringing false and misleading representations into the record. And you got to extend the sanctions accordingly. Follow Rule 11. It's for lawyers. It's not for people. Since when? Since when? Rule 11 is for people. Final answer? No, you don't have it? Okay, well then that's another perjury. Asserting these arguments. Non-presidential. In New Mexico. Without the proper case, this is territory. You are on the corporate with capital letters. So now you're bringing false and misleading information. Another 30 years for stating that New Mexico district courts have the inherent authority to impose a variety of sanctions. Oh, really? Final answer? DIS means no. TRIC means strict. Not tricked. Trickery. No trickery. New Mexico district courts. New Mexico no trickery courts. You're doomed. Another 92. Perjury 92. And another violation to Title 15, Section 1590, Title 15, Section 1692E. 30 more years. That's 360 on this side. And then you have another perjury over here. Oh, 93. You never thought it would be this much fun, isn't it? Well, we did so. And when I saw this, I thought, well, beautiful. Now I have it on writing. If I could have called you and say, write everything on writing, write everything you said, put it on writing, put it under penalty of perjury, put it under oath. And by the way, we're going to get there. This document is bogus. It's not a verified document. You know what? You didn't furnish your certificate of authority, and then you sign with the bogus name. If you sign with the B. Lowton, then you are bogus on the B. Friedenstein. If you sign with the B. Lowton, then you are bogus on the fried, on the Elizabeth fried, and so on. You know the variations on this? 4? That's a variation. Which one you want to use? New Mexico, you have no authority to practice law in territory on New Mexico territory, so therefore 94 and then courts have the inherent authority. Inherent authority, which district courts have the inherent authority? The district court has inherent authority over the people. The answer is no, and you are saying yes. Violation of Title 15, Section 1692, another 30 years. So you got another 30. On this, you got 390 years to impose a variety of sanctions. Bring them down. The right to sanction. But give me exactly why is it that you can sanction people when you cannot even deal with people? That's human trafficking. And Chief Judge Esquire Roberts Jr. in the Supreme Court for the United States cannot say different. He agreed that you're lying, you're violating, you're lying, perjury. You're being less than candid. And you cannot bring this. So this is case law. If any lawyer out there starts to do this again, this case law is going to be used to stop him and bring him in for all these years, all of these years that you have here. So no, courts don't have inherent authority. We question their authority. No, perjury 95, and question another 30 years for bringing false and misleading information into the record, and false and misleading representations, another 30 years. Final answer? Impose a variety of sanctions on both litigants and attorneys in order to regulate their docket. Their docket, final answer? Dockets, maritime law and territory. New Mexico is territory with lowercase or proper name. And you are on the corporate, in the corporate district of New Mexico. Final answer? That's another 2 perjuries and another 2 violations to Title 15, Section 1692E. $390 plus 60, $450. Plus 2 more perjuries, 95, 96, and 97. And then you read the code over here, frivolous filings. Harrison versus Board of Regents of University of New Mexico, 2013. That's code. You cannot read code pursuant UCC 1-1-103.6 to preclude a common law action. So another violation, 450 plus 30, you got 480 years. And perhaps we have Justice, we have Esquire Roberts, that if he wants to save you up, he's going to go in with you. Due to the defense's assertion of sovereign citizens, we never assert. For the Honorable J. Jesús-Arriaga Alonso and for the Honorable Adelina Arriaga Pedrosa, never assert to be a sovereign citizen. Never. Final answer? We cannot assert to be slave masters. And in which page did you see this? False and misleading representations into the record times 2, that's 60 years. 60 years on top of 480. $540. 540 years. 2 more perjuries here. 97. 98. And 99. Due to defendant's assertion, those frivolous arguments, plaintiff prays the court. Does Bank of America pray? Final answer. Ghost entities don't pray. Final answer. Another 30 years. 570 years. And another, and you are a perjury 100th. The court enter an order barring defendants for further filings without leave of court. Final answer. Since when a corporate court, has to allow one of the people to defend themselves, that's violation of the Second Amendment. In pro se is violation of the First Amendment. I will have to charge you with that. For the record, PRO means no, S-E, o Sierra Echo is no. To say. Final answer. Violation of the First Amendment. And you cannot violate the first without violating the second, the fourth, the fifth, the sixth, the eighth, the 13th, the 14th, the 15th. Unless represented by counsel. I will have trouble finding counsel for a federal judge. You will have trouble finding counsel for a federal judge. Sui juris. There is no counsel out there that can represent any one of the people. All of them are corporate, and you know it. I'm going to have to charge you another 30 years for false and misleading information or representation in violation of Title 15, Section 1692E. And all titles listed on the criminal complaint. This is on top of the titles listed on the criminal complaint. So another 30 years, 570, that's 600. That's 630. 630, you're not getting out of there. Unless represented by counsel. Is counsel attorney at law? I can say, well, yeah, bring me counsel. Where are you going to get counsel for the people? For the Honorable J. Jesús-Arriaga Abonce is a federal postal judge sui juris and cannot be represented by counsel. Federal postal judge sui juris. Think I was going to go get me one of you lawyers? And that is another perjury, 101. 101 perjuries. As the 10th Circuit found proper. This is the 10th Circuit has jurisdiction over the people. Perjury number 102. And another 30 years over here, 660 years. The 10th Circuit found proper in Norton. Where is Norton? Where's Norton? So in Norton, we are not in Norton, and we are not on the 10th District. We are in the Supreme Court Supreme Court for the United States. We are at in the International Court at the Peace Palace at The Hague, and we are in front of the United Nations at the Permanent Court of Justice. Is that the 10th Circuit awarding plaintiff attorney's fees for this motion? Oh, you want attorney's fees? Number one, you're not an attorney. Because of violation of 6 CFR 37.3, you don't have the real name. And if you have a document from the university or wherever it is that you went to law school, it does not have your name guaranteed. It does not have any of these names because you're not using your name. So another lie, another perjury, another 15 years. 103 perjury. For this motion and any further motions required to respond to these frivolous arguments and censoring defendants from raising these arguments. Oh, really? Now I'm going to be censoring. My man, you know, oh, no. Another 30 years. How can a corporate law or corporate entity, how statutory, no code, no statute under common law, you're violating the UCC 1-103.6. And you're bringing false and misleading representations into the record, another 30 years, so that's 690. And then we have another two perjuries, 103, 104, 105. Due to the nature of this motion, concurrence was not sought from defendants. Oh, really? Final answer? Due to the nature, you didn't seek the concurrence? If you come over here and you say, hey, I'm going to file this, I would have warned you and say, you go ahead and file it. You're on your own. That's your profession because of your superior knowledge of the law. And your nonfeasance, malfeasance, and misfeasance, well, you're going to Guantanamo for the rest of your life. And Judge Squire Roberts Jr. in the United States Supreme Court, or the United States, or the Supreme Court, or the United States, cannot tell any different. This is for the world to see it. This pretty much gets over with this, with all these mortgages, with all you lawyers, without all this perjury, you know. Due to the nature of this motion, concurrence was not sought from the defendants, wherefore plaintiff respectfully requests that the court, which court? The lower court? You're out of luck. The judge was disbarred 1 day before, 2 days before September 1st meeting. And it's on the record. And you were disbarred. And all these little lawyers that went in there with you representing all these little non-existing entities, corporations, they're on the same boat. They're on the same situation. Enter order striking defendants Arriaga's miscellaneous entries on December 10, 2019, December 27, 2019, June 3rd, for the Honorable J. Jesús-Arriaga is not a defendant from day one, and you have been notified. You continue to bring it on the record. Now that's perjury number 106, and another violation to Title 15, Section 1692E. You're bringing false and misleading representations into the record, and therefore you get another 30 years on top of the 690. On 690, yeah, 720. You got 720 just on violations to Title 15, Section 1692E. 720 years in jail. And these are not miscellaneous entries. Miscellaneous entries, final answer? This document looks like a final, like a miscellaneous entry. The document has a name. Notice of default judgment. So how can a lower court strike a default judgment by this superior court of record? And she has. We're going to have it on the record because we're going to play that when Judge Mercer, Cindy M. Mercer, says that she's striking it. Well, the lady did not know any better because that's violation of U.S. Code 8, Title 18, U.S. Code Section 2071. And we're going to read it for the record. Title 18 U.S. Code Section 2071, concealment, removal, or mutilation generally. Subchapter alpha, lowercase, whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with the intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing, file, or deposit with any clerk or officer of any court of the United States or in any public office, or with any judicial or public officer of the United States, shall be fined under this title or imprisoned no more than 3 years or both. Judge Mercer, in this trial by record, the record show that you strike the documents, therefore you are in violation of Title 18, Section 2071. And for the Honorable Jesús-Arriaga Monse objected for you to doing that, you should have stopped and asked under what grounds this could be read. You would have stopped, and then you didn't. You did not, as shown on the record. Whoever having the custody of any such record, proceeding, map, book, document, paper, or other thing, willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys, same, shall be fined under this title and imprisoned no more than 3 years or both, and shall forfeit his office. Then you forfeited your office. Cindy M. Mercer, you forfeited your office pursuant the record. And Esquire Roberts Jr. has to enforce and act upon a ministerial duty on the witnessing of a constitutional wrong. This is unconstitutional. As used in this section, to term office does not include the office held by any person as retired officer of the Armed Forces of the United States. Are you a retired officer of the Armed Forces of the United States, Cindy M. Mercer? Have you received a discharge from the U.S. Army? Bring it into the record. Show me that you are being discharged by the United States, not discharged. Dismissed forever. No, you're not. You're still under payroll. If you are not fully discharged. For the record, Esquire Roberts Jr. Title 18, U.S. Code Section 2071, concealment, removal, mutilation. We have this here for a reason. We didn't go look for these documents to have them just hanging in there on the wall for ornament. This is the law. Show me the law. Miscellaneous. You're lying. That's another 4 perjuries. December 2020, 2719, dos. They're not miscellaneous documents, therefore, you know you get in perjury 107 and 108. The signature blocks are also an indicator. In means no, no dick. ATOR is contract. No dick contract. Here it is. In means no, dick. Well, you know what dick is, right? Go look for it on the dictionary. ATO. ICATOR. This subscribes to the sovereign citizen movement. We went over that one. We are on the 6th page now. Now, where is your signature, lady? Where is your signature? In the alternative, dismissing the criminal complaint. Final answer. In the alternative, you want the criminal complaint dismissed when the judge is listed as a criminal. Can the judge do that? Can the judge do that? Because if you want to do that, your system is no good anymore, because any criminal can say, hey, pursuant to this case law, I'm dismissing the criminal complaint, and it's not a criminal complaint. It's just a miscellaneous entries. Final answer? Is that your final answer? Looking for here, over here, trespasser, wrongdoer, correspondent. This is case 590. 524 267. What about the Jesús-Arriaga? Is that being dismissed? Can you dismiss that? Jesús-Arriaga, the one with life, you're not supposed to be dealing with anybody live. You're a corporate. You're supposed to be dealing with dead entities, with fictitious entities, with dead people, right? And by the way, do you know the term that dead people voted? Dead people voted because they were corporatized in this election. Once Cindy Mercer is a trespasser, correspondent, wrongdoer, rapist, listed on the criminal complaint, and you have the sworn statement, which is the criminal complaint. You know, and you are listed in there as well, both of you. So you cannot dismiss it. But if you want to dismiss it, well, dismiss it. However, take mandatory judicial notice that a criminal cannot dismiss their own or his own criminal complaint. Bring me the law. Show me the law if you want to go in that direction. Criminal complaint as against plaintiff and for such other relief the court might deem proper. Deem just and proper. PRO means no. PER means no. And for the record, Esquire Roberts Jr., please take judicial notice of this Elizabeth B. Bridenstine at this address. And go to www.mylife.com, Elizabeth Bridenstine, echo, lowercase, 120-181-5709-9398, and pursuant the International Relations and Security Network, and the code number is 922039966 for the record. For the record, sir. And proceed accordingly in administering in the administration of the law or the code against all trespassers listed on attachment 1 of each one of these cases listed on the criminal complaint, case number was mentioned in a previous video. Attorney for Bank of Albuquerque, N.A. Attorney, final answer? You're not an attorney. Final answer? For Bank of Albuquerque. Okay, you're on contempt of court. Perjury 109. Bank of Albuquerque does not exist, and it clearly says over here, N.A. N.A. Not applicable. These documents were filed in this Superior Court of Record. On June 23rd, 2020, at 12 o'clock and 13 minutes, 12:13 p.m. by the Honorable J. Period, column, Jesús-Arriaga Avonce, clerk of the Superior Court of Record. In this envelope of yours, Cindy M. Mercer, you are in violation of 36 CFR slash 36 slash part 273.1 for the record. One Cindy M. Mercer is also in violation, and all the trespassers, corresponders, wrongdoers listed on attachment 1 of each one of the claim of the cases listed on the criminal complaint in the corporate district court. In the corporate United States District Court for the Corporate District of New Mexico, in violation of Title 18, Section 1341 and 1342. 30 years of prison. So we're going to give you another 30 years, Cindy M. Mercer, and another 30 years for the criminal attorney at law. 30 more years on top of 720, you got 750 years here. And we're going to count that's 45, And then we got 100 times 15. 1,545 years plus 750 years. 5, 9, 12, 1. 303,000. No, let me see. 15, 5, 0, 5, 9, 2,295 years. This Superior Court of Record hereby sentence 1. Elizabeth B. Freudenstein, Elizabeth B. Lawton, Elizabeth Fry, to 2,295 years. Squire Roberts, for the Honorable Adelina Arriaga Pedrosa and for the Honorable J. Jesús-Arriaga Abonce, Federal Postal Judges, sui juris, presiding in the Superior Court of Record and in the Supreme Court for the United States and in the Peace Palace at The Hague, at the Permanent Court of Justice of the United Nations, here in this video, adopt your oath, remind you, bind you to it, remind you of a fiduciary duty, extend sovereign immunity while you carry the orders of the Queen and the King. Justice John G. Roberts, for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa, hereby accept your oath, bind you to it, remind you of a fiduciary duty, extend sovereign immunity while you carry the orders for the Queen and King under Title 28, Section 636, Subchapter Gulf, temporary assignments in a court of under martial law, Rule 203, jurisdiction over the offense. And for the third time, Justice Roberts, Squire Roberts, in the Supreme Court for the United States, for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa, accept your oath, bind you to it, remind you of a fiduciary duty, extend sovereign immunity while you carry the orders under this Title 28, Section 636, Subchapter Gulf, lowercase, and administer the law against all trespassers. And listed, given names listed on attachment 1 of the criminal complaint in the Corporate United States District Court for the Corporate District of New Mexico. So 3 times. Now you have to act upon a ministerial duty or compound to the same constitutional wrong. It is hereby. It is so ordered on this 18th day of February, Thursday, 35 minutes past 3 o'clock, for the record. It is so ordered. Let the record show that for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa have adopted the oath and compel John, Juliet, Oscar, Hotel, November, space, capital G, capital Golf, space, Romeo, capital Oscar, Bravo, Echo, Romeo, Tango, Sierra, lowercase, space, Juliet, capital, Romeo, lowercase, Chief Justice in the Supreme Court for the United States, you solemn oath compels no less from you, is on the record. We were going to play a video, but we are finding out that to upload this will take forever, so we will continue at a later date and upload the video in which is going to be essentiated. However, for the Honorable J. Jesús-Arriaga Ponce and for the Honorable Adelina Arriaga Pedrosa, have invited for the Honorable Robert Allen Radlusky to bring in this video, to bring on the following video, all documentation that has been submitted to the Court of Appeals on a case, and it is not part of this case, but the documents are introduced as the same documents here that they have submitted as forgery. Mutilation of the documents is violation of U.S. Code Section 2071 of Title 18. This will be read into the record once more in the next video. And then we are going to be bringing the insurance company, Allstate, and for the time being, we'll have to take a break until then. We're going to leave you with an image. Chief Justice Roberts. We're gonna leave you with an image of the Geneva Convention's POW handbook, and for you to act upon a ministerial duty and restoring the liberty of two federal judges kidnapped by the corporate state of New Mexico. Two federal judges sui juris indigenous people kidnapped by the United States government, as shown on the record. Thank you very much for your attention, and proceed accordingly in the administration of the law. Your solemn oath compels nothing less from 1. Robert, no, from 1 John G. Roberts. Your solemn oath compels nothing less from you. Peace to the gods.